Okay, so today we have Stephen and Tom. Mr. Golden has been involved in suing banks for wrongful foreclosures, which is very important for most homeowners to learn and know what your rights are in a foreclosure, right?
Definitely.
Great. So our first question is, what is the homeowner's bill of rights?
Yeah. It's called the California Homeowner Bill of Rights. It was enacted first in 2008, became effective in 2009, January 1st. It was amended and made stronger in 2012, became effective in 2013 with some changes in 2018. But effectively, what it does is requires the banks to look for, in good faith, alternatives to foreclosure. When the homeowner is in default or about to be in default, requires the bank to contact the homeowner and try to work with that homeowner to avoid the worst case scenario, which is a foreclosure. And that may include a forbearance where they don't pay for a while and try to get a position to pay later. It could be a modification. It could be to sell the property, give them time to live there, but various alternatives, refinance. In some situations, you can bring an investor and pay the bank off. There are various scenarios that the bank should be looking at to avoid foreclosure. That's the main thing. The other thing is that while the bank is proceeding to investigate and research whether the homeowner is a viable candidate for some workout other than proceeding to foreclosure, that the bank can't go and then start the foreclosure process and hit them in the back of the head by foreclosing, having a foreclosure sale while they're purportedly working with the homeowner. And that's called the prohibition against dual tracking. Those are the main provisions of the Homeowner Bill of Rights to allow the homeowner some time to see if a solution can be had to keep the property or to get out gracefully, not to be foreclosed on with the resulting problems with the credit and eviction. In essence, that's what the Homeowner Bill of Rights does and is.
So, technically, the bank is supposed to reach out, right? In simple
Supposed to.
words, they're supposed to reach out
Yes.
and speak to the homeowner
Correct.
and say, hey, let's work out something.
Correct.
And if they can't get a hold of the homeowner, like by telephone or mail, what else can the bank do to not violate the rights for the homeowner?
Well, there are remedies if the bank did not work with the homeowner to try to resolve an imminent default or actual default, meaning that homeowner is behind in payments. There is adjunctive relief. A homeowner can go to an attorney. That attorney can file a motion in the court and stop that bank in its tracks, and has been done many, many times by attorneys over the years, and that is very effective and gets the bank's attention, and that attorney can get his or her attorney's fees reimbursed for having to go in and stop the bank from doing what it's not supposed to do, which is proceed to foreclosure and not try to work out with the homeowner some solution.
So there is a great benefit in hiring an attorney
There
while you're
can,
going through a foreclosure.
there can be what I would suggest is the homeowner, in his own good faith, try to work out with the bank. But if they get the runaround in most instances, they do need to go and talk to an attorney and see if that makes sense. An attorney that not only knows the laws but also knows bankruptcy laws, that knows that person might qualify for a reverse mortgage, maybe a situation where someone could co-sign to a refinance. Say they have an interest rate at 6%. Current market rates might be 5%. That spread of 1%, 1.5%, may be the difference between being able to continually make that payment or not. Sell the home, short sale, which is the bank accepts more than what's owed on the property. They get gracefully out. They don't have a foreclosure and all the resulting damage to the credit. Or they actually sell it and get time to sell it and get money out. So the worst thing in the world is to allow a foreclosure. There's no way that should happen if they're talking to a team of individuals in the area who know how to properly advise that client.
So that explains it really well. When you say dual traction, so it's illegal for a bank to foreclose when a client is during a loan modification or a short sale, right? They can't foreclose. That would be the dual traction, right?
Yeah, dual track. It's dual track. They're operating two tracks. One is they're trying to work with you purportedly. At the same time, they're actually proceeding down the train of a foreclosure. Tom could discuss briefly how that works because he's working with the banks in his experience, and they just seem to ignore and don't work with the homeowner. That's happening.
Well, a lot of times they do, and there are various violations that occur under HBOR once the client goes into default. And even though they have certain rights, those rights are violated by the banks in the form of dual tracking. They are supposed to have a single point of contact or dedicated person for that homeowner to talk to, and a lot of times they have random people that they talk to. And while they may be discussing something with one person to work out a solution, the foreclosure department or loss prevention department is proceeding with foreclosure in the dual tracking mode, which puts pressure on the client and shows they're not acting in good faith. And a lot of times the banks really don't want to work with the client. They really prefer to foreclose. When they foreclose, they get all their fees, all their late fees, all their penalties, and they're happy. That's all they really want a lot of the time.
I just want to add this. When the bank has foreclosed, it's not the end of the day. There have been instances where attorneys have been able to actually reverse the sale, and that has happened. And because there are liabilities on the homeowner bill of rights, if they didn't do the due diligence while they're doing the dual tracking, there are extreme penalties in the law. And in some instances, when the bank took the property and didn't sell it to a third-party buyer, they will, recognizing the potential liability and attorney's fees and all of that, will go ahead and rescind that sale, and that has happened. That's because of the incentives in the law and the penalties against the bank for violating the homeowner's bill of rights.
So the last question for this in the foreclosure is, why is it that the bank does not give you a formal decline letter that your loan modification was declined or your short sale was not approved? Because a lot of the times they'll just tell you from one day to the next, sorry, your loan modification was declined or your short sale was declined, and now you have full effect foreclosure. Your next sale date is like less than 15 days.
I'll let Tom answer this also based on his experience, and then I'll give my answer too. Go, Tom.
Yeah, there's where you need an attorney, because obviously in that scenario, they violated the homeowner's bill of rights. They have a legal obligation to notify you in writing, to give plenty of time, and you have a right of appeal to any decision that they make, either in the case of a short sale or a loan modification. And if they violate those things, then someone with a knowledge of the law, an attorney, a paralegal, someone who has that insight, can go in and use the law to
the reason the bank sometimes doesn't do what they're supposed to do is they're not properly advised as to their duties under the law, and not knowing the homeowner bill of rights, they many times will, through mistake, error, lack of training, will not notify the homeowner properly, or through mistake, that the modification was denied, the short sale was denied, and then we'll proceed with the foreclosure. But they're supposed to, and sometimes it's just, I don't know if it's intentional, but I think it's many times just recklessness and mistake.
Yeah, and a lot of times the personnel that are involved in those scenarios that you're talking about have done this time and time again, and the homeowner who is not initiated, they're not knowledgeable, they end up losing their home, there's no repercussions, so the personnel will keep doing it. Once they meet a client that has an attorney that opposes that, then they'll be a little more careful oftentimes in the future.
So what happens if a homeowner lost his house during a short sale? Because this has happened a lot, and they never came back and sued the bank because they never got a declined or not approved letter for their short sale. Can they still go back and sue after like maybe a couple years passed?
Yes, in some instances they can. If in fact there was reliance by the homeowner, the homeowner had a realtor, and the realtor and the homeowner and the bank agreed that, okay, accept the short sale, and typically there's an agreement between these entities, the homeowner and the buyer, and the bank, or there's indication that they will extend the sale date of the property while they're going to complete the short sale. In that instant, the homeowner relied on the bank's misrepresentation and could have done other things to protect their equity, and then the bank violates their agreement, violates their promise, and the homeowner loses the home, loses the equity, and yes, that's not only 2 years, that's a 4-year statute of limitations, so conceivably within 4 years. And why would it matter? Well, if there's loss of equity, then it certainly could matter to that homeowner. If you're talking about if it's a short sale, then there's not going to be a loss of equity, but there could be some other emotional distress damages, other damage to the credit, and so it all depends on the situation.
Yeah. And not only that, if there's a contract with a third party that comes in, they want to buy this house, they have rights as well.
Third party.
And their third party rights are violated in that scenario.
Wow, I had no idea that even the buyer had rights
Oh yes.
on a short sale.
Yeah.
Okay, well, thank you very much. Thank you.
Okay.